When is it appropriate for a judge to impose a sentence enhancement under the guidelines?
Thank you, Senator. The federal sentencing guidelines are crafted to assist courts in making sentencing determinations within the broad range that Congress prescribes for cases, for crimes. So in the typical case, a defendant is convicted of some crime. In the federal system, they're usually very serious crimes. And Congress will say, Judge, you can give that person a sentence anywhere between 0 and 20 years, for example. The sentencing guidelines are designed to set out a series of factors that judges should be looking at when they decide what they're going to sentence that particular person to. And those factors will be things like, if this is a violent crime, does the person have a weapon? If this is a violent crime, was there any injury? And so the judge is looking at these facts, in many cases horrible facts, and calculating the guidelines based on what we call enhancements. Each one of those different characteristics or conditions is an enhancement. So you ask, when is it important when it's appropriate? Well, the judge has to calculate the guidelines in every case. That's how we start the process. But under the statutes, in addition to calculating the guidelines with all of those enhancements, the way our system now works is you determine what the guideline range of punishment is going to be, and then Congress says you look at a series of other factors in addition to the guideline range. And at the end of the day, the judges in the system now are choosing sentences based on both the consideration of the guidelines and also the consideration of the statutory factors that Congress has put forward.
Have you ever declined to impose an enhanced sentence on a defendant because you disagreed with the enhancement as a policy matter?
Thank you, Senator. Yes, and the reason is because of Supreme Court case law concerning the way in which the guideline system operates. The Supreme Court has determined in a case we discussed yesterday that the guidelines are no longer binding on judges, meaning the guidelines you calculate, but you don't have to stay in the guideline range anymore. That was the Supreme Court's Booker case. And I can't remember if it's in that case or in subsequent case law, but the Supreme Court has also made clear that when you are calculating the guideline range in the new system that we're in right now, judges are free, the Supreme Court has said, to decide in particular cases whether, as a quote-unquote policy matter, they disagree with a particular enhancement. That is the state of the law. That is what the Supreme Court has said judges are permitted to do in cases. And so I have, in certain cases, given the way in which the guidelines are operating, the disparities that are created in cases, I have at times identified various enhancements that I have disagreed with as a policy matter because the Supreme Court has said that that's the authority of a sentencing judge in our system.